In this podcast, we're going to look at how an administrator investigates the affairs of a company and their powers, liabilities, and right to what's called indemnity. So we're going to be turning our minds to what an administrator actually does. So the fundamental role of the administrator is set out in section 438, capital A of the Corporations Act. Essentially, they take control of the company from its directors whilst the company's financial position is temporarily protected by a general moratorium on claims by creditors. So they begin investigating the affairs of the company with a view to deciding what is in the best interest of the company's creditors. And after forming a view as to the future direction of the company, the administrator makes one of three recommendations to creditors. And I mentioned those in the previous podcast. I'll mention them again. So they are, first of all, they could recommend the execution of a deed of company arrangement, so a DOCA, to regulate the relationship between the corporation or the company and its creditors. Or two, they could make a recommendation to the creditors, and this is done during the second creditors meeting, to terminate the administration and return the company and control of the company to its directors. Or three, they could recommend the liquidation of the company. So that is for the company to be wound up. So one of the early things that needs to happen in this process is the investigation. So the investigation occurs with the purpose of the administrator forming an opinion about each of those three options on your PowerPoint. So while the administrator recommends one of these three options, we will see later when we consider the second creditors meeting, it is quite clear that the administrator's recommendations must address all three of these possibilities. And then they recommend just one to the creditors meeting. So the investigation phase is in fact very important. So the directors are required to assist the administrator, who's an external person coming in. So the administrator has a right to the company's books, or alternatively to inspect them. I'll put the relevant sections on your PowerPoint. So this is of course an important part of facilitating the investigation of the company's affairs by the external administrator, the external person coming in. So it's quite likely that in conducting the investigation, the administrator may reveal certain parts of the company's business that demonstrate that there's been a contravention of the Corporations Act, so an offence committed by a current or past director or officer of the company. So under section 438, capital D, which is on your PowerPoint, the administrator must report to ASIC, notifying ASIC of any of these indiscretions. And we'll see next week that the same applies for liquidators. So it is these reports to ASIC that are often the source of prosecutions that you looked at when you considered the corporate governance model. So let's move on to look at the powers of the administrator. So the administrator takes control of the business and also the property of the company. The administrator has power to manage that business and also to dispose of the business itself or of any other property of the company. And this is set out in section 437, capital A of the Corporations Act. In undertaking the role and responsibility of the administration of the company, the administrator is deemed to be an agent of the company under section 437, capital B of the Corporations Act. And it can exercise, so the administrator can exercise any power of the company or its officers. And this is clear under section 436 capital A subsection 1 paragraph D. During the administration, the powers of the directors and all other officers of the company are suspended under section 437 capital D. And the case on your PowerPoint, so the case of Brash Holdings and Shafir, makes it clear that there is no role for the members during this period of administration. So this is an important point. Members do not play a role in voluntary administration. So the powers of the administrator are exceedingly wide. And in the case of Brash Holdings, it was held that the whole of the business could be undertaken without reference to, to the creditors or the shareholders prior to the second meeting of creditors. So they're quite broad powers, and you should have a look at section 442 capital A, please. Okay, so in the second case on your PowerPoint there, in the case of Patrick Stevedores, this case considered the impact of the court's powers under section 447 capital A as against the powers of the administrator. And the court found that the court's powers don't allow the court to remove discretionary powers of the administrator. Okay, but this case is also authority for the proposition that the administrator's powers are also not unlimited. So the administrator's powers are largely in relation to the conduct of the investigation into the company's financial affairs, and that the administrator must undertake that investigation lawfully. So it is the administrator and only the administrator that has power to deal with the company's property and business during the administration period. Any transaction entered into by anyone else on behalf of the company during that period is void unless it's accompanied by a court order. Section 437 capital D makes this clear. Okay, so the administrator's role is not without risk. The administrator is personally liable for debts that are incurred in the course of the administration. And this includes for any services rendered, any property that is leased or used, and any goods that are bought. It also extends to money that is borrowed with interest and costs during the period of the administration. Have a look at section 443 capital A. So why would anyone want to be an administrator if that's the case? Well, an administrator has a strong statutory right to indemnity. So how does this really work in practice? So the role of the administrator really informs the scope of the administrator's liability. The role of the administrator initially is really to take control of the company's affairs, isn't it? And then to make recommendations to the creditors about the best of the three options regarding the future of the company. So this means that the administrator is both an officer of the company in accordance with section 9 and also an agent of the company. So generally speaking, administrators of a company will not be personally liable for the debts of the company for both of those reasons. And this is because of the notion of the corporate veil and the concept of separate legal personality. So what is the administrator personally liable for? So an administrator is personally liable for debts incurred in the course of the administration in relation to services rendered, goods bought, property leased, used or occupied, and the repayment of money borrowed, interest, and costs of money borrowed. So this list comes from section 443 capital A of the Corporations Act. And this is the case this is the case because we want to or try to encourage trade creditors to deal with a company that is in administration. So that's the rationale for administrators being personally liable in these situations, in this way. Because this is vital where the administrator is attempting to carry on the business of the company, isn't it? For trade creditors to be prepared to deal with the company. It does act, though, as a disincentive to the administrator taking on contract liability in circumstances where they couldn't be supported by the company's assets. And just note, Section 443 capital A cannot be contracted out of by an administrator. Okay. And finally, for this PowerPoint, the administrators the administrator's right to be indemnified is in fact also afforded priority ahead of other secured credit. Okay, so thank you for listening to this podcast. You're welcome to move on to the next when you're ready.